She was 17 years old, sitting in a courthouse hallway, her father freshly buried, her caseworker leaning in close and whispering that today was going to be brutal, that they were going to tear her apart on that stand, and that she should probably just sign the papers. So she did. And for 15 years, she wondered every single day what happened to the little girl she left behind. Then one day, her phone buzzed. It was her daughter, now 17 herself, and she was asking for help getting out. This is one of the most emotionally complex legal situations you will ever hear, and it raises questions that thousands of parents who lost children to the system are too afraid to even ask out loud. Stay with me, because what happens next matters, and so do your rights. To understand the weight of this story, we have to go back to the beginning. A young girl, just 15 years old, becomes a mother. She is not living in a stable home. She is surrounded by addiction, incarceration, and chaos. Her own mother is using methamphetamine, and that is what originally opens the door to a DHS case. The Department of Human Services getting involved not because of anything this teenage mother did, but because of the environment her own mother created. But here is where things get complicated immediately. At the same time, this 15-year-old girl has her own hot UA, a positive urinalysis test, for marijuana. And at the time, marijuana was still illegal in Colorado. So now she has her own case attached to her. She is a child herself, navigating a child welfare system that was never designed to support young parents, especially not ones born into generational cycles of poverty, addiction, and instability. What makes this story even harder to sit with is what this young mother actually did. She enrolled in college. She stopped using marijuana entirely. She cut ties with every person from her old life. She was doing everything that the system asks struggling parents to do. And she was doing it at 17 years old, which most adults would find nearly impossible even without a child welfare case hanging over their heads. But there was another dynamic at play. The foster home where her baby was placed was run by a woman who, according to this mother, had her own motivations. This foster mother was Mormon, unable to have biological children, and had recently been through a divorce. The biological mother came to believe, and would later have strong reason to believe, that this foster mother was not simply caring for her child temporarily. She was building a case to keep her permanently. She would call the biological mother late at night, drunk, checking in on the baby. That detail is important, and we will come back to it. Then, within months of each other, two devastating things happened. First, this young woman found her father for the very first time, a father she had never known. A month or two later, he was shot and killed. She had found him and lost him in the span of a few weeks. And then came the court date. The caseworker pulled her aside and told her that the termination hearing was going to be intense, that they were going to bring up everything she had ever done wrong, every mistake, every stumble, every imperfect moment of a childhood she never really got to have. And then the caseworker told her she probably just did not want to go through that. She probably just wanted to sign. She was grieving. She was exhausted. She was 17, and she signed. She signed away her parental rights, and the adoptive mother promised her things. She promised not to change the child's name. She promised to send pictures as the little girl grew up. She promised that this would not be a complete severing. Every single one of those promises was broken. The name was changed. The pictures never came. For 15 years, this mother had nothing. Not a photo, not a word, not a whisper about how her daughter was doing. And then, 15 years later, the daughter, now 17 herself, reached out. What the daughter described about her life was not the warm, stable, loving home the system had decided was better than what her biological mother could provide. She described an adoptive mother who is an alcoholic. She described physical abuse. She described a woman who controls her by taking away things she cares about. Her phone, her belongings, her sense of safety, anytime she steps out of line. And here's the devastating twist. This biological mother had already raised red flags about the adoptive mother's drinking while the placement was still happening. She told her DHS caseworker. She told people. Nobody listened. The system that removed her daughter to protect her placed that daughter with someone who would spend the next 17 years abusing her. Now the daughter wants to meet. She wants a phone, so she has a lifeline that cannot be taken away. And her biological mother is asking the question that anyone in her position would ask. What am I legally allowed to do? What laws could I be breaking? Let us talk about the legal reality in Colorado, because this is where the facts matter enormously. First, the biological mother's parental rights were terminated. That is permanent, and it means legally, in the eyes of the court, she has no parental relationship with this child. She cannot make medical decisions. She cannot enroll her in school. She cannot legally intervene in how the child is being raised. That is the hard truth. But here's what she can do. She can communicate with her daughter. Receiving a message from her daughter and responding to it is not illegal. Talking to her is not illegal. A 17-year-old reaching out to a biological parent is not a crime, and a biological parent responding is not a crime either. Providing a phone to a minor is a legally gray area, but it is not inherently illegal. A gift to a minor does not constitute custodial interference on its own. Custodial interference, which is the charge that would actually be relevant here, generally requires taking or enticing a child away from their lawful guardian. Buying a phone and giving it to a teenager so she can communicate does not meet that standard in most interpretations. Meeting with her daughter in a public place, with the daughter's knowledge and consent, is also not automatically illegal. The daughter is 17, not 7. She is months away from being a legal adult. Courts and prosecutors generally do not treat a teenager voluntarily meeting a biological parent as a criminal act when there is no deception or force involved. However, and this is critical, if the biological mother does anything that could be construed as encouraging the daughter to leave the adoptive home, hide from her adoptive mother, or resist lawful custody, that could cross into custodial interference territory. She should be very careful about the language she uses, even in text messages. Here's the most important thing she can do right now. Consult with a family law attorney in Colorado immediately. Many offer free initial consultations. She should also document everything her daughter tells her, dates, descriptions, specifics, because if there is ongoing abuse happening in that home, that information may need to go somewhere. Colorado has a child abuse hotline, and given that the daughter is still a minor and describing physical abuse, there may be grounds for a report that could trigger an investigation. 6 months. That is how long until this daughter turns 18. At 18, she is a legal adult. The adoptive mother has no more legal authority over her. She can walk out the door and no law prevents it. The biological mother can house her, support her, build a relationship with her, and nobody can legally interfere. So the most legally safe path right now is this. Stay in communication. Do not do anything that could be characterized as interference. Document the abuse allegations, consider whether to report them, consult an attorney, and count down the 6 months until the law is no longer a barrier between them. And for anyone watching this who has lost a child to the system and is wondering if there is ever a path back, sometimes there is. Not always through courts, not always through legal proceedings. Sometimes it is just time, and a 17-year-old with a phone, and a mother who never stopped waiting. What this story teaches us is something that gets buried in legal language all the time. The system is not infallible. Caseworkers can be wrong. Foster placements can be harmful. Promises made in courtrooms get broken. And a young person who once had no voice grows up and eventually gets to speak for themselves. If you are a biological parent who lost rights and your adult or nearly adult child is trying to reconnect with you, talk to a family law attorney before you do anything. Know what your state's laws say about custodial interference. Document every communication. And if that child describes abuse, treat that seriously, both for their safety and because it matters legally. If this situation sounds anything like something you or someone you know has been through, whether it is a terminated parental rights case, a reconnection with a child who aged out of the system, or navigating the line between staying in contact and crossing a legal line, drop your questions in the comments. We read every single one. And if you want more real legal stories like this one, cases that do not make the news but change people's lives, subscribe. New videos every week, and we never shy away from the complicated ones.